In Mannings Organisation Ltd versus Joseph Henry Manning, Andrew Kinnear KC, sitting as a Deputy Judge of the High Court, determined the sum payable on account of costs following an unsuccessful discharge application brought by the defendant, Joseph Senior, against an injunction obtained by Mannings Organisation Ltd and Mannings Amusements Ltd. The discharge application had been vigorously pursued and included serious allegations against the claimant's solicitors and counsel. Because the injunction and discharge applications shared overlapping issues, including whether a serious triable issue existed and whether full and frank disclosure had been given to Foster J, the claimants could not produce a statement confined to discharge application costs alone. They instead submitted total litigation costs of £165,355.84 and sought 40% as a good faith apportionment. Joseph Senior contended that only 20% of the return hearing costs, plus the costs of preparing the Wallace witness statement, were properly attributable to the discharge application, producing a figure of £25,160. Applying Rule 44.28 and the principles established in Excalibur Ventures LLC versus Texas Keystone Inc., the court allocated half of counsel's fees, half of solicitors' attendance time, and the full cost of the Wallace statement to the discharge application, totalling approximately £40,000. A further 10% of total costs was allowed for items that could not be cleanly separated, producing an attributable figure of 35%, namely £57,874.44. Given the imminence of trial and the difficulty of attribution, the court assessed recovery at the lower end of a 65 to 75% range and ordered Joseph Senior to pay £37,600 by 4 p.m. on the 6th of July 2026. Quote, "There are, in my judgment, two principal factors in assessing a reasonable sum in this case. The difficulty distinguishing the costs of the discharge application from the broader costs of the litigation, and the imminence of the trial. As to the first, a balance needs to be struck between the difficulty of identifying the costs that are truly attributable to the discharge application and the cautious approach already taken to determining the costs incurred in dealing with it. As to the second, the expedited trial means that the parties will not have to wait long for detailed assessment, and some weight should be attached to that consideration."
For a detailed summary of this decision, visit tmclegal.co.uk.